there's many ways of introducing each of you. To me, and I think to LCW, the easiest one is to say you're all friends of LCW. I leave it to you to decide which hat you want to talk about, what hat you wear today, and how you describe yourself over 30 seconds. And then if you can respond to Mukta's report and Anmol's report first, any comments, questions you have of her and Anmol, and maybe even I'll take a couple of questions from the audience if they have, and then we'll open to some wider questions ahead, which might be silly, so we'll keep it for the last. Is that okay with everyone? Shall we start with you, Shomona, starting here? Thank you.
My name is Shomona Khanna. I'm a lawyer. I practice in the Supreme Court and in the Delhi High Court. And I should also say that I'm part of a collective of lawyers and legal experts called the Legal Resource Center. And we work on indigenous peoples and forest rights. So that's my hat.
And your questions, if you have
Yeah.
comments or questions.
So I actually haven't had the opportunity to study this report properly because I was supposed to be in the next panel. So, but I did, follow closely what you were saying and also speed read while you were making the presentation. There is one thing that it's not a question, it's more a comment. In the work that we do and the work that I have sort of done over the last many decades of my law practice, especially when working with Adivasi communities, it's very important to recognize that when we are talking about any kind of violation, any kind of dispute, any kind of conflict, any kind of sort of aberration from the law, we treat the constitution as the base for that, because it is an overarching social contract. And I just felt I kept going back to that particular section where you say constitutional violations, because seriously they're all constitutional violations, each and every one of them. And I'm not just saying that as rhetoric, but we have made a lot of effort in the work that we do as the LRC team to actually trace back these specific violations to specific provisions in the constitution and to the fundamental rights chapter. So for example, if you're talking about the Adivasi rights under the constitution, there is a tendency among even people who are in the tribal rights movement, Adivasi rights movement, to start with Article 244, but actually there is very rich case law that actually traces the fifth schedule, the sixth schedule, Article 244 to Article 14 of the constitution, and then of course to 15, 21, 25, 29, 19. So those I feel that we live in times when holding on to the constitution is so important and vital. And Usha was saying in the previous session about how there has been this rupture that the constitution marks with the colonial period. And I sometimes feel a little bit I mean, okay, it's a lot of work to be done in terms of bringing that knowledge to people on the ground and getting them to recognize that you're not talking about a violation of simply how an arrest is to be made, so a DK Basu judgment, or a violation of the Land Acquisition Act, because does Section 105 apply in this case or not, or does Section 24(2), how is it to be read in a particular situation? But we trace it back to the Constitution, and the Constitution is a social contract, and we hold the state accountable. So I think then that really makes it, in some ways it may look like it's complicating the situation, but it makes it much easier to traverse that situation. And as lawyers, certainly it makes life much easier for us to decide what we're going to argue and which side we're going to argue from.
Hi, I'm Mohammed. I'm a friend of LCW's. I'm also an advocate, and I've had the privilege of working with them on this report. So I have a certain degree of familiarity with what has been presented, and I can say that it is indeed one of the most comprehensive and thorough analysis of the subjects that exists as on this date. I want to say one thing. I think Mukta's entire presentation can be summarized in one line. No one covets land like the government. It doesn't matter which end of the ideological spectrum a government falls on, whether it's capitalist, communist, or somewhere in between. No one covets land like the government. All those statutes that you laid out, the Land Acquisition Act, the Forest Rights Act, the Forest Conservation Act, what do they all have in common? They are designed to protect you against the excesses of the state. And that is the unique nature of these statutes. All other statutes protect you against private excesses. All other statutes protect you from harm by a fellow man or woman. But in this case, these are statutes designed to protect you from the government. What Mukta has done is what Mukta and Land Conflict Watch have done. They have given you a bird's eye view of what a tumultuous last 8 years it has been when it comes to land acquisition. Now, I'll just take a minute to summarize some of the stuff. Now, see, the history of land acquisition in India can be divided broadly into two phases. There is the 1894 Act. That act makes no apologies about the fact that it is designed to help the government take over land. It is designed to do so expeditiously, in the cheapest way possible, and with the least amount of fuss. So your rights are completely on the margins when it comes to that statute. And this was acknowledged by and large. There's half a century worth of writing post-independence which point out how bad a law it was. But because it suited every single government that came, it remained largely unchanged with minor modifications and amendments through the years. The second phase of land acquisition in India starts in 2013. Everybody acknowledged that the law is bad. Excesses were being documented on a daily basis. Judges of the Supreme Court were speaking out about the 1894 Act and saying it is a colonial piece of legislation. It should be consigned to the dustbins of history and so on and so forth. So a very responsible government in the form of the UPA2 took the responsibility and drafted this law. And this law would mark a unique departure from all that came before it because it did four things. It changed the way compensation is calculated. It increased the ceiling to a point that governments, if you read, Nitin actually wrote extensively on this at the time. If you go back and read the comments submitted by other government departments, you will find that every single government department objected to this law. They said we will not be able to afford the compensation. I'll be very, very quick. I won't get into too much detail because every single pillar demands its own narrative. Then it changes how you respond to the government. It gives you the power to consent to an acquisition. It gives you strength in numbers. It says that if 60 to 70% of you decide you do not want to let this project go forward, it will not go forward. Third, it creates a system of social impact assessment. Earlier, under the 1894 Act, I just had to take your word for it. If you're the government and you say that I need this land for a public purpose, I cannot challenge it. Court after court after court refused to step into the shoes of the government and say whether the purpose for which the land is being acquired is actually public or not. That was how much power the government had to decide what constituted public purpose. So for the first time in 2013, a law came about that actively defined comprehensively what public purpose is and demanded that a report be prepared attesting to that public purpose. You can't just say it's a public purpose. You have to demonstrate that it serves a larger public good. So there's compensation, there's consent, there's SI. And fourth, there's rehabilitation and resettlement. You can't just pay people for their land. You have to ensure that they're rehabilitated and resettled because moving someone off their land is an extremely unnerving process, right? It completely disrupts a person's life in a way of living. So this law comes up with those protections. So then from 2014, we get the second phase where the Supreme Court passes judgment after judgment after judgment, starting with the famous judgment called Pune Municipal Corporation in 2014. They pass judgment after judgment after judgment, returning land that has been unjustly acquired, or land which has been acquired and not been used, or land which has been acquired and for which compensation has not been paid. There are close to 75 judgments between 2014 and 2017 where the Supreme Court and numerous High Court judgments where the courts are returning land to the people. Then comes the third phase, and this is where things start to change. And this goes back to my point why government, nobody covets your land like the government. The government realizes it's losing land banks at a rapid pace. So what does it do? So for the very first time in history, at that time, the government of the day did not have the numbers in the upper house of parliament to pass amendments to this law. So what do? They encourage states to pass their own laws to override this. Now, normally when there's a conflict between a state law and a central law, the central law proceeds, right? But in this case, using powers under Article 254, subclause 2, the center gives them permission to pass their own laws which undermine the central law. This has never happened before and never since, to the best of my knowledge. And so states start coming up with their own laws. One of Mukta's charts pointed out to the various state laws that have come into force since then. And another thing happens. The Supreme Court turns. Suddenly there's a shift of attitude. Between 14 and 17, you have these judgments where the court is not even indulging in any degree of hemming and hawing, and they're simply interpreting the act as it's meant to be interpreted. From 17, there's a judgment called Indore Development Authority. Yes, Namita is more of an authority on that, so I'll leave that to you. After Indore, a judge of the Supreme Court, a two-judge bench decision of the Supreme Court, basically reads that section under which land was being returned into oblivion. That section had 4 components. I won't get into the legalese of it, but every single one of those 4 components was read down to a point of nullity. It was interpreted in a way that it would simply not work. Imagine cogs arrayed against themselves, they both can't turn. And everybody pointed this out to the bench, that the way you have read the law will simply ensure that not a single person will benefit from this. And this wasn't a hypothetical. This actually came to pass. After 2017, because that judgment is in conflict with the 75 plus judgments I told you about, it's referred to a 5-judge bench. The same judge who passed that judgment, again, this is my opinion that it shouldn't have happened, but this is fact, that the same judge who pronounced that judgment, finishing off those 75 and reading this section into oblivion, he sits in review of his own judgment, along with 4 other judges. In fact, he's the lead judge. The lawyers spend a large amount of time trying to convince him that, sir, you cannot sit in review of your own judgment. But he says that I am open to having my mind changed. Spoiler alert, he didn't. By the end, they end up reaffirming this judgment, Indore Development. And since 2017 onwards, no land has been returned. This third phase, so the first phase was the 1894 Act, the second phase was the golden years of the 2013 Act between 14 to 17, and the third phase, which is where we are now, is the Indore Development phase, where no land is being returned. I'm only talking about the beneficial provisions here. I'm not getting into compensation. I'm not getting into how land is acquired today. But in all of this, there is a lesson for us. To my mind, and that's why reports like this are so very, very valuable. They, A, remind us of how far we've come, and B, they remind us of what we have to fight for, right? Because it's very easy to forget. I mean, people no longer remember that period between 14 and 17 where we had a very progressive Supreme Court when it came to land acquisition matters. And people certainly do not remember, except for those who were impacted, about the period between the 60s, 70s, 80s, and 90s, where you were entirely at the mercy of the government. Do you know the half-life of litigation for land during that time? It was 15 years. There were disputes in 2014 that were still pending from the year 1960, 70. 2 generations of people had come and gone, and those litigations were still pending. That is why these reports are important. That's all I have to say.
Hi. For any one of you who thinks this is a rigged match, we got our friends here to say we are doing good work. That's not true. Most of them can be very critical when they need to be. I hope they are today as well. This is really not like a judge reviewing his own case in this in this case. Namita and Mukta, if you wanted to respond to.
No, I'll let you know.
Okay. Namita, please. Feel free. I'll let you know if you're going past.
Good afternoon, everyone. I'm Namita Wahi. I'm a senior fellow at the Center for Policy Research and director of the Land Rights Initiative. It's a great pleasure to be here. Thank you, Sambhav, and the entire team for organizing this dialogue and sharing such wonderful research with us. Sambhav and I started our journey in the land space together, I think, and it's great to see over the last decade the work that has been coming out, and always wonderful to be with this group of people on this panel. So those are the nice things I'll say.
Shit, is it going down after this?
No, in a few minutes. No, so I think I have only read this report so far and not the others. But if Nitin, if you may permit, I would like to just say a few things. You had a fantastic panel in the morning and the presentations that were made on the earlier report as well. And I just thought I'd share some thoughts inspired by the reflections there. So, one thing that we need to understand whenever we talk about land is that land is not just an economic resource. It is central to individual and community identity, history, and culture, which is why there is so much emotional attachment to the land, because it's not just a source of livelihood. 60% of all Indians today, so we are 1.26 billion people, 60% of all Indians today are directly dependent upon land for their livelihood. This number, 75 years ago, we are proudly celebrating India's 75th year of independence. In 1950, this number was 80%. So at the time we became independent in 1950, when we adopted the constitution, 80% of all Indians were dependent upon land for their livelihood. And agriculture and allied activities contributed more than 50% to our GDP. Now, 75 years later, still 60%, and in absolute numbers, the number is much greater, because the population of India at the time of independence was 350 million. We have now quadrupled our population, so 60% of that quadrupling of the population is much, much more than the 80% who were dependent. So that many more people are still directly dependent upon land for their livelihood. But the contribution of agriculture and allied activities to GDP has gone down to 25%. And therein lies perhaps some of the explanation for why land and land reforms have really not been on the agenda of the government. There were some questions in the morning as well. That why is the political establishment, and Mohammed has candidly admitted that all government, I think he means all political parties, all political persuasions, you said that, they all, when it came to the state government, so just to put a number to it, 20 state governments have amended the progressive law that Mohammed worked on and pioneered. Your team, Jairam Ramesh, and you pioneered. 20 states have amended the law to eviscerate it of its core content. The 4 things that he was talking about, consent and SIA, which were key to the law, at the heart of the law, have been eviscerated by the states. And these are all state governments ruled by all political parties, from the left to the right. And, one of the, apart from the fact that, government covets land, I think the issue is really about power and historical legacies of power. So it's much easier to do something when you don't have to give up something you've held for a long time. If you look at Indian history, I mean, if you look at the history of British colonial rule, I mean, in 300 years in a nutshell, it's 1600, the East India Company comes to India. 1793, we have the permanent settlement. This is the first, and there we also see that the history of our freedom struggle, as well as the history of British colonization, has been punctuated by land conflict. And that brings me to one of the questions that Nitin, I think you had sent before the panel, is that, is conflict a good or a bad thing? And in my opinion, it's a good thing. So Bukta also referenced the land acquisition report that we had put out 5 years ago, and one of the things that that report studied all legal disputes that had been decided by the Supreme Court over a 66-year period, and our conclusion was that if you give that conflict is going to happen if you are going to take away people's land, and this is a violent and it's a forcible process of acquisition. If that happens, if you give people rights, they will go to court. If you don't give them legal rights, then there will be conflict on the ground. And in many ways, the excellent research that the Land Conflict Watch has done in the past and now encapsulated in this report that Mukta and Anmol have put out, is the fact that much of the conflict is over common land. Whereas if you look at litigation under the Land Acquisition Act, which, and therein lies the importance of data work and stories as well, because the reason why we did this land acquisition report in the first place was because in 2015, when the ordinance that the central government was passing to amend the law, there were 2 narratives that were coming up. One of the narratives was that this law, which was the government narrative, that this law was going to make acquisition impossible and stop all development. And that stalled development was due to the inability of companies and so on to pay compensation. So at that point of time, I just set up the Land Rights Initiative, and I was asking people, like, where is the data for this? Where are you getting the fact that, this is going to stop all development and acquisition? I spoke to people, colleagues from CPR went on to head the Niti Aayog. I asked them, I said, where is the data? There was no data. It was just rhetoric. And that's when I started working on the land acquisition report, because with judicial data, fortunately, the judiciary is one branch of government that has to record its reasoning. It has to come to conclusions and has to be preserved because of the nature of precedent. Government departments don't do that, right? So it is they're supposed to do that, but they don't always do that. It's very hard to get a repository of government administrative decision making on any subject. So that's why we started with judicial data as an attempt to understand why are people going to court for these conflicts. And the results were that, and something that we identified in that report, that 2/3 of the cases were for compensation claims and 1/3 was for procedural irregularities. And I think that your report has also found similar findings with respect to procedural irregularities. And I remember that Usha, who was here in the morning, Usha ji said to us at the time we launched our report that even the claims that you have classified as compensation doesn't necessarily mean that that the non-payment of compensation is also a procedural irregularity. Right. So I would also suggest you to look at in the way you classify these, your different categories, is that how do we understand procedural irregularities, and how can we define that in the report, whether it's a narrow definition or a wider definition. And the second thing she also mentioned then was that, like, even those who are accepting the compensation don't want to give up their land. And I think she reiterated that in the morning when she said that there is this sort of, helplessness within the people, and nobody wants to give up their land, so they will fight it the way they do. And so at that point of time, what we had also said is that litigation is not a preferred process. It is always the last resort. And our work, both in the report as well as the interviews we've done with various stakeholders over time, indicates that it is the last resort when government completely violates the rule of law. Whether it is with respect to assessment of compensation, whether it is with respect to whether the public purpose for which the land is being acquired. So there were 3 categories of cases. Public purpose was the least contested because courts usually don't get into public purpose. They defer to the government, and rightly so, because courts should not be deciding. In a well-functioning democracy, the government should be representing the will of the people. But that's not what always happens. And the other 2 instances, we also found that with respect to compensation, most of the times the government loses. And yet, Supreme Court is the highest court. So a compensation case has to go before the civil court, and then to the High Court, and then to the Supreme Court. And yet the government appeals as an automaton every single case that they lose. And as a result of which, we have a lot of litigation in the system. So data that we've put together over the years indicates, and also Daksh has put together data, that 66% of all civil disputes pertain to land. 25% of all litigation in the Supreme Court, we estimate, pertains to land. 30% of that 25% litigation, so a third of, a 12th of all disputes pertain to land acquisition, where the government is a party, where the government has acquired land. And the fact that the government keeps appealing these decisions prolongs the resolution of these cases. And I think that might be something to look at for the report as well, as, why are these disputes being prolonged? Who is prolonging it? Because once you're in a dispute, you can't really get out of it till it's resolved unless you pull out. But it's something as valuable and important as land, you're not going to pull out, because your entire livelihood depends upon that. Now, your finding completely resonates with the findings of both the land acquisition report as well as the scheduled areas report that we had put out. And that's because, the Land Acquisition Act only recognized the rights of title holders. So one of the important innovations of the new law was the fact that it also recognized the rights of livelihood losers. But unfortunately, the new law has not been much implemented, especially, Mohammed has covered the Indore Development Authority judgment in 2020, which really was another setback along with the state amendments to the new law. But, under the old law, only title holders could bring claims. What does that mean? That only person who has legal rights, which is only to private land. So that is why you see litigation of a private land. Makes sense. Because on common land, and I'd written a policy brief in 2019 on understanding land conflict in India, and therein I said that there are two narratives about land, and going back to the history of land conflict. See, what the British state did in the process of colonization was essentially to derecognize the rights of existing people on the land. And every state, so the reason why the GDP numbers are important, because every state works in a way as to increase revenue for the state for whatever purposes they want to do it. So for the colonial state, the major source of revenue was land revenue. So their policy was to bring as much land under private cultivation as possible. And so there were two departments. There was a revenue department which covered land revenue, and then there was the forest department. The forest department was also a source of revenue. It was not really to protect forests, but it was essentially to derecognize the rights of. So if you look at the history of forest policy from 1868 onwards, the first policy refers to tribal rights. Then it is diluted to privileges and concessions. And then, of course, the forest rights, the forest laws of 1868 and 1878, then, they completely derecognize the rights of forest dwellers. And, pretty much like the Land Acquisition Act, even the way they are drafted, Section 4 allows them to notify any area as forest land. Section 4 of 1894 Act allows them to acquire land. So that is how, and then it goes on to the 1927 Act. Now, our scheduled areas report showed that most of the forest cover in India is concentrated within the 5th and 6th scheduled areas. So 70 years after independence, nobody had actually mapped the scheduled areas. So we had created a map of the scheduled areas. And in the morning, it was mentioned that 15% of districts are scheduled area districts. So 13% of India's geographical area we estimate is scheduled area. Even in those 15% districts, which is about 100 and, so there are 640 total districts. Within that, actually only 51 districts, the entire district is scheduled area. In all other districts, only certain parts are scheduled areas. And there was a question in the morning about what happens, with an urbanized body. And there was a presentation, the stories that from the ground that were presented about how these protections of the scheduled areas, the PESA and the FRA, are done away with simply through an administrative order which declares something as an urban area. And because the Municipalities and Extension to Scheduled Areas Act has not been enacted, despite, so, there are ways of diluting the constitutional safeguards. And I'm so glad that you spoke about Article 14, because, that's 14, 19 and 21, the composite code. And I would argue 31 as well. So I kind of disagree with what was said in the morning. I mean, Proudhon is very polemical, but, as Marx refuted him and said, theft is property. Because the assumption that property is theft also assumes that we have a property framework. So you can't get away with that, within. And Marx's argument, of course, was based precisely on the rights of forest dwellers, because he has this famous essay, The Law on the Thefts of the Woods. He said that basically you have derecognized the rights of forest dwellers to forest produce. This was in Germany. And the same thing we saw with the forest laws in India. So I think that we should not get into those kinds of binaries, because even within the government, the fact that the Ministry of Tribal Affairs is now the nodal agency for implementation of the Forest Rights Act puts it into conflict with the Forest Department. Similarly, I feel that, when Navdeep in the morning was talking about businesses, and, I really think we need to look into incentive structures. Can we create, so when we interviewed bureaucrats with respect to the land acquisition report, they said that we have to appeal all the decisions, because if we don't do it, then we will be under investigation. There'll be a central vigilance inquiry against us. So even if they know that they're going to lose, they have to do it to protect themselves. The individual bureaucrat has to protect him or herself. Similarly, if we look at the companies, thank you.
This is when I turn evil. Sorry.
Yeah. Similarly, if we look at the businesses, we spoke to several businesses at the time we were doing the report, and they said that, land is only 5% of the cost, and this is to companies where land is the main, cost. I mean, real estate development companies or big infrastructure companies. Land itself was not the most costly thing. But when you're used to getting it so cheaply, when you're used to getting common lands that are being grabbed at 1 rupee per acre, as happened in the Mundra coast, then obviously your costs will go up, and you haven't factored that in. So those are some of the things, that we need to think about, that how do we reorient the incentive structures of various actors in the story. And but quickly on the report, I think it's a fantastic addition to the body of work. I think the findings very much resonate with existing work we've done. I would also suggest, you've identified, just to put some number on the kinds of laws, we're talking about land acquisition. Our 1000 land laws project estimates we have already collected 130 laws of land acquisition, central and state laws that exist. So I think that there's just so much law also. So we've only collected laws for center and 8 states, and we have already got 500 original laws, let alone amendment and validation and repeal and repealing laws. So for all of India, I estimate there are at least 3,000 land laws. So there is a lot of law, and when there is a lot of law and there is conflicts between laws, there will be conflict also. Because there'll be one law that a community will use and one law the state will use to push their claims, and there will be that's when the courts and the judges and everyone will get involved. And I think we have to remember that as someone said in the morning, lawyers are sort of brokers within that system of power. Whether it's just like your local patwari is a broker on the land with respect to the administration, the lawyer is your broker with respect to these things. But I also feel that that the law is a tool. And there've always been different narratives also about the law. We have the Austinian conception of law as the command of the sovereign, where the sovereign can be a monarch or it can be the will of the people. But we also have the Savignian conception of law as Volksgeist, the law which represents the spirit and consciousness of the people. And we have both kinds of laws. We have the 1894 Act as the law as the command of the sovereign. We have the Forest Rights Act and the RFCT LARR Act as representing what the people want. And I think that going forward, we have to have more of the second kind of laws. And finally, I would just say that the greatest imperative for all of this is the flow of capital and financial. I wrote this paper on the right to water earlier this year. One of the interesting things, we were looking at all litigation relating to right to water, and one of the interesting things that came out was that the reason we have so much water scarcity is that because the British policy of building irrigation canals was not necessarily dictated by where the irrigation canals were most needed, but where there would be the most secure returns on capital. So if you're going to build an irrigation canal in an area which is completely arid, it was not a good enough investment for the financiers in London.
Namita.
Yes.
Sorry, I'm going to be such a horrible person.
Yeah, just 30 seconds. Now, now that we have like global capital, all over the world flowing and dictating priorities, there is a disconnect between who is setting the agenda for the government, whether it's in terms of, the business entities who are paying revenue and so on, but also who is funding the policy space and who is, supporting what kind of work that makes it possible for us to create these narratives. So I'll just stop here, that we need to trace the flow of capital as we figure out how to deal with land. And, even within development, there have always been different discourses. Development hasn't always been understood only as growth. And I think with the climate crisis, and I call it a crisis because it's not change, it's not reversible. The climate crisis does give this opportunity, and the indigenous imagination of Jal, Jungle, Zameen, forest, water, land as an indivisible ecosystem, I think is not just crucial to protection of land rights of indigenous communities, but to sustainable survival on our planet. Thank you.
See, I told you how tough it will be to rein this panel. It's very difficult for me to do this. I'll ask all of you to be kind to me. Fernando, unlike I think most panelists on this, is a recent friend. If I can say this, I think we've only conversed 4 times since we met each other. And most often we've conversed about everything else except land. And we've conversed about him having a second child, him trying to come to India desperately even during COVID, and him actually agreeing to tie up with LCW without even knowing what LCW was. So he's landed in a soup. He'll try to swim out of it. What I'll request, Fernando, compared to other panelists, what I'd probably love to hear from you is also the work at LCW particularly is focused on India and what's happening here, and perhaps attempts to solve things here. from your understanding of rest of developing world in particular, not just not developed world, is the nature of the questions you heard and the conversations you heard different? Is the kind of data that you're seeing and the patterns you're seeing emerge very different? My guess is it's not, but perhaps you know better.
Thank you, Nitin. Well, I will not introduce myself again. Just Fernando. It's fine. If you don't know how to pronounce it, remember the ABBA song. And if not, you probably can hear the drums, Fernando. Anyway, I will not, as Nitin said, I will not delve into Indian law. It will be unwise, almost irrespectful, taking into account that I'm surrounded by Indian lawyers who know quite well, and probably some of the top in this issue. I just will make a few comments, really few, because it looks like Namita and I agreed before. Most of what I was planning to say about the report was already said. But I will make first a few comments about the report, just to show that we are not the judge judging his own judgment. I already said this to Mukta. I think that that the report is really an impressive piece of work and is very relevant and needed. I will, however, particularly in the demands and contentions of the affected communities, the fact that it shows that the majority of complaints against procedural violations could be understood as willingness and awareness of the communities, or also can be shown, they're not exclusive, over lawyering. For those who are not lawyers, when you have a problem, the lawyer have to translate it into something that will get you what you want in court. Therefore, let's do a completely ridiculous example. You are accused of a crime that you didn't commit, and your lawyer says, you know what, let's go for probation. So, but I didn't commit it. I know, but the probation, you don't do anything, you never acknowledge that you committed the crime, and in 6 months it's gone. If not, we have 3 years. Therefore, if you see that in a report, you say, oh, look, all these people got probation, when it probably is not necessarily related to the actual problem. And when you see such a large number of procedural violations, it just rings a bell. So is that really the problem? Or is just over-lawyering, trying to get a quick result, which is, by the way, is quite well done. That is what lawyers are supposed to do. You have a deeply rooted land conflict, and there is no way of solving, and you need to stop a project, you go for the procedural violation. My point is, this is absolutely needed, but probably we need to go beyond that and to see what is the actual conflict behind the procedural violation. So we don't risk, we don't know what has happened, to hide the actual conflict behind what I always call over-lawyering. It's just one comment that I already made to Mukta, and I think that in future reports could be added. This is what happened in court, but this was the original conflict. So we don't hide them behind a wall of counts. And that can be observed that the most, even if you go to the second and except until you reach the third cause, they are all proper lawyers' constructions. It's just something that can be added. As it is, it's impressive anyway, by the way. So let's talk about what Nitin wants me to talk, other countries. As you probably heard before, if you were here in the morning, I'm originally from Argentina. I lived many years in Japan. I lived in Thailand. I worked in Nepal, United States, France, and now in UK. That doesn't make me a specialist in any of these countries. I'm just telling where I lived. But I observed and I participate in mainly in conflict resolution processes, not in the legal side, except in Argentina. And what we are observing here is an international trend, particularly in the South, where, as was said in the morning, due mainly to politics, not law, the state perverts its own aim and take the sides of those that go against the will and the interests of the people. We need to be very clear about that. Is a prostitution of the aim of the state. That is not the point of the state. The fact that the state is involved in many common land dispute is plainly obscene, and it happened in most countries that you have a substantive number of land conflicts in the global South, where the state's side, and I'm sorry, I was telling today, I'm clearly not a Marxist, but I will keep using Marxist language. The state sides with the oppressor. This is unique. This is quite new in history. You would argue that in common land you will have the big corporations trying to get the people that have lived there for centuries, but it's the state. We see the same in Brazil. We have seen the same in Ecuador. We've seen the same in Colombia. We've seen the same in Nigeria. We've seen the same in India. It is a particular period in time. Nevertheless, I'm normally accused of being quite pessimistic. So today I will just light a candle just for once. Nevertheless, something else is happening. Because United Nations, that we normally go there to complain about how much money they spend, our money, by the way, and how little they achieve, they did something in the last year that was declaring the right to a clean environment a human right. And that changes things. Because another thing that happened when Baltasar Garzón decided, and a Spanish judge, to judge a dictator in Latin America, and that dictator thought that he was safe going to England. What happened is that the House of Lords decided many years ago in Pinochet, Ugarte, and Home Office that human rights violation can be tried anywhere in the planet. And then you suddenly see that a local judge in The Hague takes to court, accepts a case against Shell for violation of human rights at global scale due to climate change. And then you see that in France, the Friends of the Earth take to court Total, again for global violations. And suddenly, when the state of India is deciding to ignore the wills and the interests of the people, might start to face that. And particularly when the aim is what we were referring today, we remember that this is not necessarily accepted, what I call growth and not development. So you will see in the literature development. I just disagree. I don't think it's development. If the state that is not fulfilling its mission as a state, but is fulfilling any other mission, pursues that, investors, international investors, will know that they could be sued where they are from for things that they do here. And that is the new thing that is happening. Just to end with case law, unfortunately, lawyers like to talk about cases. The UK Supreme Court just decided in Okpabi against Shell, or Anne Shell, as lawyers said, that Shell could be sued in UK using UK law for damages caused by a subsidiary in Nigeria. Therefore, when you have a land conflict here with a foreign investor, now the foreign investor knows that you or friends or an NGO can take them to court where they come from, when probably the judges care a bit more. So what you were describing before, the Supreme Court deciding that a state law can contradict a national law just because, I think the quote of the court was, because they follow proper legislative procedure, it's plainly ridiculous. If you do that in my class, you fail. That plain. Because if you follow procedure according to that, any law will be valid. And I think we don't want to talk about Germany 1936, 37, because there were many laws that were following procedure, and we don't know how it ended. So I think that we have a way forward. We have a way forward with the internationalization of human rights. It's easier. It is more direct to be able to use constitutional rights. The problem is when you find it's yourself in front of a state that is not wanting to play the game. It's planning to actually not follow the rules of the game. And related to the issue of human rights of particularly indigenous people and land, for those who cannot use the forest, the particular provision in Indian law of community ownership in land that is not forest. Well, in Connors and UK, the European Convention of Human Rights decided that the right to live in common life is part of the human right to have a family life and a private and family life. I do understand that applies only in Europe, but as I said, human rights are slowly entering through the window in many jurisdictions. I'm going to be short this time. I will surprise you, Nitin, because you always know, I talk too much. But I think that the internationalization, although it sounds strange, particularly when you have states that want to reinforce the national identity, I understand that. I know that is very difficult, but it might be just is another way forward. I don't think it's the only one. I think these problems are so complex that need a very complex strategy.
Thank you. It's something Fernando said, and I'll try and bring it back to the panel after the first round, which was this issue of internationalizing, say, land, environmental rights, labor rights. Has been a contentious thing in the past few years in India itself. It's always been a question of, does it work? Should it work? Should we do this or not? I'll come back to this, and it might be a little diversion away from just the issue of land because it applies across the board. But I think it's worth provoking each other on. Geetanjoy, can I take your permission? Because Arpitha has been sitting on a chair looking at a screen. If she could go first. Arpitha, thank you so much for waiting for us. So.
Of course. Can you hear me?
Yeah, a little louder perhaps.
Okay, is this better?
Yeah, sounds good.
All right. Thank you so much. It's such an honor to be a part of this panel, and I've had the pleasure of reading the report, and in some ways I'm both a friend of LCW but also a fan, so I'm going to make my bias known from the get-go.
Arpitha, so sorry if I may intervene. Two things. One, if you could introduce yourself, and two, please don't reveal such secrets. They'll realize it's a rigged match here.
No, but my comments will probably show otherwise. So I'll make sure that my bias is known, but it doesn't define my thoughts on the report. My name's Arpitha. I'm an adjunct professor of law at NYU. And I guess one way to introduce myself is a bulk of my work has looked at land acquisition in forest areas, particularly in the mining sector. So a lot of my comments will sit at that particular intersection. So to begin with, I think the report to me is such a salient piece of work because, as much of the panelists have said, not only does it give you a bird's eye view of how land conflicts occur and shape lives and the law, but also gives you a granular account of how it plays out in the different stages. But having said that, I do feel like the report to me has very, very fascinating nuggets that can still be brought out and expanded on. And I think the data is there. It just needs to be sort of used and harnessed more effectively to tell those stories about the law. And a lot of my comments, I must say, are derived from my work with Adivasi communities in Orissa for my doctoral thesis. So I don't take credit for any of the smartness of these comments. I owe it to them and their sort of legal mobilization efforts. So the first is the proceduralization of a substantive claim. So one of the things that a lot of social movements in forest areas have enunciated time and again in my interviews is a substantive right to land, and especially common land and in forest areas, has been reduced to a procedural requirement of consent. So this kind of proceduralization of justice has created more control and has become a technology of control for the state. Because you have a situation where discretionary power of the bureaucracy in terms of how procedural aspects like consent are implemented have not been entirely challenged. So how much does it actually allow the state to be challenged on its excesses? So is procedural law even the right way to go? And I think Shomona ma'am has made that point amply with the sort of focus on constitutional law. And similarly, Namita has spoken about it as well. One of the interesting observations that Adivasi communities and social movements pushing back against land acquisition in Orissa make is sort of what they call the moving scale of unpredictable behavior of the state from authoritarian to democratic. So it's almost like the state can be sort of selective when it takes on its democratic avatar and when it takes on its authoritarian avatar. And the law allows for that range. And so I think that gradient of understanding what allows the state, despite these democratic protections, to remain authoritarian, especially in forest areas, is key. And it's about not characterizing the state in a very simple form, but to actually show the window of the black box of the state and how it functions, which kind of sort of leaks into my sort of second point. Which is one thing about forest areas, and I think a lot of the panelists have already made this point, is that conservation and laws around conservation are nothing but legal instruments to solidify state control, right? And I think in those contexts, the biggest challenge we're trying to see is who is the worthy steward of these lands. But actually, there's like a very there is a collision course of conservation and extraction happening simultaneously, and the laws enabling both of them. So in some sense, conservation solidifies state control, and that allows for easier extraction. So identifying those flows, I think, is important. The last set of points that I have are based more, I think, are both methodologically inclined, and I think probably, again, your data addresses it, but needs to be brought out more clearly. So sort of doing more deep ethnographic work. So picking, like, while you've gone for scale, I think picking like maybe, say, out of these 689 conflicts, a good sample size of like 30, and doing a deep dive into them. And the reason I suggest this is because in my own work, one of the biggest realizations on the land acquisition process in forest areas, and this point of a due process deficit that we keep bringing up, is sort of the informal artery of actors involved and procedural innovation that happens on the go. So like you have, say, industrial development corporations involved. You have land acquisition teams within these companies that are trying to extract, operating informally and negotiating informally with communities. And that creates a very different story of the informality of law, which influences the formal legal process. So what does that interaction really look like in a lot of the conflicts that you've alerted us to? And I guess the last 2 points that I'll make are sort of in a similar vein is, and I know that much has been said about litigation and when do communities choose to go to court and what leads them to courts in context of land conflicts. In just my deep dive of 3 land conflicts in Orissa, what I've realized is that social movements are clever legal operators and clever legal strategists. So they look at legal action as an ecosystem and being very interconnected. So it's not like the protest that happens is seen in isolation of a letter that gets written to the district collector to eventually approaching the court. And so it's a very fascinating sort of way to look at how do all those different legal interactions, whether through a timeline or happening concurrently, interact. And I think kind of that view of legal mobilization will really enrich a lot of the stories that you've been telling us. And I guess the last point is the point on the fear of courts. So, in a lot of the social movements that I have looked at closely, the courts are definitely, I think, like Namita said, sort of the avenue of last resort. But it's not like they close out the conflict in other avenues. The conflict remains alive and bubbling in a lot of different kinds of legal avenues. So, to be more explicit about it, in say the POSCO case that I was looking at really closely in Orissa, even though the case went to court and was going through its own process there were multiple sort of informal negotiations underway with the district collector. And these were sort of administrative processes happening on different kinds of grounds. Similarly, there was a lot of pushback on with IDCO, which is the Industrial Development Corporation in Orissa, just on the construction of a boundary wall. And then there was also a case happening in the High Court as well as the National Green Tribunal. So I think it's just that spectrum of legal action, and to contextualize the fear of courts, not just as a simple dialectic of like regulatory failure on the administration to be complying with procedural law, but rather it is taking something that's so complex and then pushing it into an adversarial setting. And what costs does that mean, and how does that sort of impact their lives on the ground as well? So yeah, I'll stop with that. And I just wanted to say congratulations again to the team, and thank you for having me.
Hey, Arpitha, I hope that thank you for having me here is not meaning that you're going to shift away from the chair. You need to hold on for another half an hour.
I'm here.
All right. Geetanjoy, please. So sorry for keeping you waiting till the end.
So my name is Geetanjoy Sahu. I'm associated with the Tata Institute of Social Science, Mumbai campus. Perhaps I'm the only non-legal panel member here in this session. Oh, you are there. Okay, so by training, I'm a political science student. By default, I work on interface of state and society. So whatever I'm going to speak, given my non-legal background, so some of the statements are going to be politically incorrect, legally also incorrect. So excuse me if I say that. Now, congratulations to the team for this wonderful report and Mukta for this presentation on the legal analysis of land conflicts. And many of the findings, especially I'm going to talk about one of the findings in your report, that is 41% of the conflicts are resolved at the community level, and which is very consistent with the existing legal scholarship on legal disputes. Why people are not going to court? There are many reasons, because I see there are inherent weaknesses in our judicial system, and I'll be focusing on 2 dimensions here. One is the procedural side of the legal system, and the second is the philosophical side of the jurisprudence. Now, if you look at the procedural side of jurisprudence, and I'm not going to talk about private land, common land, which Namita already talked about. I'm going to largely talk about the environmental conflicts which have been documented in this report. Now, if you look at the procedural side, after the passing of the National Green Tribunal Act, and we have one of the architects of the act sitting in this panel, Mr. Muhammad Khan. So when the law was drafted, and perhaps this is also the only environmental legislation in the last 12 years which was democratically, intensively debated in the parliament, where Environment Minister Jairam Ramesh gave assurance to the country that we'll have more benches in the coming years. So at present, we have one principal bench, though the word principal was not there, but some of the judges try to consider Delhi as a principal bench, and 4 zonal benches. Kolkata bench, Chennai, and then you have Pune bench and the Bhopal bench. Now, if you look at the philosophy of the National Green Tribunal when it was set up, like what Upendra Bakshi said, in the post-emergency period, many attempts were made to take justice to the doorstep of people. NGT was one such attempt in 2010, where it enjoys enormous power, more than what the High Court of India is enjoying. It has appellate powers, where it can overrule the government's decisions on merits. It is also not binding by the Evidence Act of India, rather by the principle of natural justice. So this is how the philosophy of the law was conceptualized when the National Green Tribunal Act was enacted. But if you look at the last 12 years experience, and Ritvik Datta and I wrote a piece last year detailing the significance of NGT and where do we stand after 10 years. Now, after 12 years of NGT, now in 2022, there are serious problems with this justice system. That's why people are trying to resolve at the community level. Now, the procedural side, if you look at the NGT, which is supposed to have 10 judicial members and 10 expert members, for the last 12 years, never we had 10, even minimum members of judicial 10 members. And if you look at the other procedural dimensions, the so-called access to justice that was conceptualized, but in the last 5 to 6 years, judicial members are not there. Only you have 6 judicial members. You have 5 non-judicial members. And unfortunately, if you look at most of the experts who were supposed to have a degree in the field of environmental science and engineering, most of them are retired bureaucrats coming from Indian Forest Service, coming from Indian Administrative Service, with little knowledge in the field of environmental science and technology. And they have been part of this decision-making process. There are matters which are arbitrarily dismissed without giving a chance to the affected party. The principle of locus standi, which judiciary expanded in the post-liberalization period, now has been under challenge. There are comments made by the benches, both in the principal and the journal benches, very derogatory comments against the petitioners who bring these laws to the court of law. So from procedural side, all those spaces that were supposed to be for the affected party to go to the court, to the bench, now they are subverted. That is what I see in the last few years of procedural side for the jurisprudence. And then there are also several challenges if you look at some of the inconsistency in the matters. Now coming to the philosophy of the jurisprudence. Now earlier it was with Supreme Court, and Supreme Court expressed inability that we don't have ability, expertise in the field of environmental science. That's why NGT was set up. And NGT was supposed to take a more scientific and systematic approach towards jurisprudence. But last few years, if you look at the philosophy of NGT, and to a great extent also the Supreme Court, largely, if not exclusively, they are driven by 2 dominant values. One dominant value is the value of neoliberal principles, where they think that every societal problem in terms of the idea of development can be done through market forces, can be done through huge investment, can be done through only infrastructure projects. The idea of development is always seen in the name of larger investment. In all these cases, whether you talk about earlier, we had cases like Narmada, Tehri, Dhanu Power Plant, Bangalore Airport, and yesterday Prime Minister inaugurated 2 projects, Nagpur Samruddhi Express, Mopa Airport in Goa. In all these cases, invariably, the Supreme Court earlier, now NGT, has been emphasizing that they are important in the name of public interest. They have added more adjectives to these public interests. Now they say national interest, strategic importance, national security. All these projects are justified, and the reasons that are given that they are policy matters, as if other cases are not, we don't want to intervene. The other reason is given, it is too late to intervene because already huge investment has been done, like Manoj Mishra's case with reference to Art of Living case, or you take any other case that you know, huge investment case, Akshardham Temple, Commonwealth, all these cases, the court and now the NGT has been trying to justify in the name of public interest. The other reason that the court also gives, that they are cases which involve scientific and technical details, and we are not experts. And if you look at the last 10 years, even after NGT coming into picture, the purpose was the expert members and the judicial members will arrive at a decision taking all the scientific and legal aspects. But in the last 10 years, more than 120 committees, expert committees have been appointed by the NGT only, which are supposed to deliver based on the support from the expert members. So delegation of power is done to the committee members, which was legally wrong. Even the Supreme Court recently held that NGT cannot delegate its power to the committees. So all these projects are now justified. And the second dominant value, in addition to the neoliberal value that we are witnessing, that is the value of Western environmentalism, which is highly exclusionary in nature. So there are many cases which have come to the Supreme Court and High Court in the recent past, where they take a pro-environment, pro-conservation position, but that pro-environment, pro-conservation position is not inclusive in nature, where they consider tribals are encroachers, where they consider slum dwellers are not required for the city, they are nuisance for the city, fishing community members are not taken into account. So all these cases, whether you talk about city beautification of Mumbai or Delhi or Bangalore, the slum dwellers' rights are not taken into consideration. Same thing is happening for the tribal rights. Invariably, if you look at the last few judgments, whether it is Supreme Court, a very regressive judgment came few months back, last February, where they said you need to evict if they have not submitted the documents, if they are encroachers, if their claims are rejected. So these are the two, values that we see in environmental jurisprudence, where one is justifying the larger interest without taking into consideration many of these legal issues, and they justify saying they have already invested, so they apply the principle of fait accompli. The maximum thing they are doing in every case now, they are saying you go for plantation. Every case you say that the last paragraph of every judgment, the companies should do 10 lakhs plantation, 4 crore plantations, 3 crore plantations. And then you have very symbolic judgment which are against the microstructures. Like when municipal bodies are involved, the judiciary comes down heavily. And if you look at the last 1 year judgment of NGT bench, Punjab government was penalized 2,000 crores, Bombay Municipal Corporation was penalized 12,000 crores. They are all symbolic. And most of these orders passed by the NGT, they have been challenged in the Supreme Court. Either Supreme Court has given stay order, or within few months, all these orders have been set aside by the Supreme Court. So this is a very serious concern. That's why community members are not going to court, and they think that instead of having this kind of a very, very inconsistent judiciary, and more specifically when you look into the conservation versus human rights issue, infrastructure projects versus the illegalities, the Supreme Court and now NGT has been consistently inconsistent when it comes to all these matters. Now coming to the observation that you made, that 41% of these conflicts are resolved at the community level, I would also urge your team to further look into the deeper side of the story. Because when you say 41% of these claims are resolved, and we know most of these communities who engage with the state or at the industrial bodies at the local level for raising so many demands, like the charter of demands you talked about, better compensation or sort of rehabilitation. But these are also communities who are holding land. But what we need to also highlight the impact of these kind of community level resolution on the landless community. Because very often the landless, marginalized communities are not in the picture of resolving this at the community level. And I was also curious to know, but when you talked about impact on lives, there was a slide, I think, when Mrinali was presenting, that 34 people were killed, 55 people were arrested, some 37 lathi charge, whatever you talked about. But when you say impact on lives, what also it undermines impact on the livelihood of the people. So there are thousands of people who are landless, and in the LAR Act, affected communities are defined in a broader way, where it doesn't refer only to the landholders but also the landless people. In most of these community-based resolutions, you don't see their voice, the landless people in the negotiation, because they are either migrating or they are helpless. And very often, since I work in Maharashtra largely, I see many of those migrant workers, daily wage workers who lose their livelihood. You find them very often when you get down in Dadar station or Thane and Borivali, and they are distressed migrated workers from the rural areas who are landless. And unfortunately, again, when they come to Bombay with the hope that they will get some livelihood, we have another regressive law, that is Bombay Beggars Prohibition Act, which section 4 of the act allows the police person or any person authorized by the authority to arrest anyone who begs in the in the city. So I think that is equally important. When you talk about impact on life, we need to also get into the deeper side of the landless community and their livelihood. So I'll stop here. Thank you.
Mukta wanted to respond.
Am I out? Yeah. Yeah, so I just want to respond to a couple of the panelists. So both Fernando and Arpitha mentioned the issue of proceduralization of substantive claims, where when we say that communities have complaints against procedural violations that could conceal the fact that there are underlying issues and other substantive claims being made. So I agree that on one hand, that could be the effect, that there are underlying claims that are not being brought out. But on the other hand, these procedural complaints and procedural issues raised by communities also shed light on when communities resort to procedural interventions in order to get a foot in the door as an actor in the conflict. So that was the intention of involving that as one of the contentions made by the communities. And also we map these contentions on multiple factors. So there could be multiple contentions made by a community in one conflict. It wouldn't necessarily just be one. Arpitha also mentioned the value of case studies and research, and that's something our research is primarily very data driven, and it's an attempt to gather and condense legal data where there exists a huge gap, and naturally data has its limitations. And an example of that is in a number of cases, not in a number of cases, but in at least one case where a court had disposed of a conflict and the conflict had resolved on the ground. The reason of resolution of conflict was not that the court had disposed of it and that the verdict was accepted by either party to the conflict. So that is definitely a limitation of data and something that that requires individual case studies in order to shed light on it and actually get a comprehensive picture. And more qualitative studies are definitely something that we hope to focus on in the future. But the purpose of this exercise was to use macro trends in data in order to arrive at some conclusions to shed light on that. And Geetanjoy's point on looking at the impact of community level resolution on landless communities is well noted, and it's definitely something we'd like to explore. Thank you.
Okay. Of course.
And also, Namita mentioned that there are different kinds of laws, where one kind of law could be the command of the sovereign as a directive that comes from the government, versus other kinds of laws that more reflect the will of the people. And that reminded me that an observation we'd made in our research is that there are some legislations that have come through after long history of struggle by people and people's movements. For example, the Forest Rights Act of 2006 and the 2013 Land Acquisition Act. So what we've observed is that there are some cases where the law that is of the nature of the command of the sovereign, like the 1894 Land Acquisition Act, would have people outright refusing to give up their land for the project or demanding rehabilitation despite the fact the law doesn't provide for it. But on the other hand, when you see laws that have come through people's movements, you actually see people demanding the implementation of the law itself. And there was another question that was asked earlier about what is legal versus what is just. And we can see that in laws that have come through people's movements, what people are demanding and the justice that people are demanding actually comes very close to what the law provides as well. Thanks.
I'm reminded of a law I think none of you would have documented from my area that I belong to partly. It's called the chicken spirit law. When the government of India was building roads incessantly since I think 2000 in Arunachal, the typical laws that are pursued on this side of the chicken neck are not pursued. Also, the nature of governance is very different on that side than it is on this side. So very often our people would do something very simple. They would throw a chicken in the middle of the road when the people were trying to construct a road. And then they would say, if you kill our chicken, you kill a spirit inside the chicken and you pay us compensation. And it would disturb the administration a lot because you cannot argue against the spirit. And there are customary rights which are to be protected. People's practices have to be respected. Nobody, even a marauding murderer, would still think no, customary rights should be protected in that side of the chicken neck particularly. So people would take money and obviously have a good treat afterwards, because what would you get for a chicken? If you negotiated very well for the spirit of a chicken, you could get up to 40,000, 50,000 rupees, which is substantial because an entire village could have food out of it. So people got smarter over time. They started throwing 2 chickens. And then the neighboring village said, no, let me throw first because I get a better rate for the first one, the second one. So they even had disputes about who will throw the chicken first. There was once I remember where 2 villages had a meeting together to say, okay, how many chickens from which side and when. And the poor state authorities were completely flummoxed by this because they would keep reading laws and saying, oh, but under the law, this is this is that, and saying, that's all fine, but the spirit. So I wonder sometimes, and different people alluded to in different ways. Is law really the force? Is politics? How do people play the game that's been played in courts or outside? All of you alluded to in some ways. And something that was said even in the first panel, to think that people who are fighting these battles are silly victims is very stupid of us. There's a phrase that one of my friends, Khonjay Borbara, who's from Guwahati, uses. It's the cunningness of the underdog. It's quite essential to recognize that's critical for most people to survive, and that's what's used. It's not the intelligence of the powerful that saves. I think a lot of this conversation that was going on today through this panel previously reminded me of that. I'm constrained by the fact that if I don't close this panel too quickly, the last panel may not even get to talk much. So what I'm going to do, with your permission, is to open to a couple of questions from the floor, unless either of you have a quick comment to make against each other's thoughts. So sweet. Thank you. So first 2 hands that go up. Oops, one was smart enough. Yes, please. Would you introduce yourself and gentleman there in the jacket and check shirt? Yes.
Yeah, my name is Trishant. I'm a postdoc at the University of Cambridge. My question is particularly to Arpitha because she mentioned that conservation laws solidify state control. And while the FRA guarantees rights to, before that I should mention that one thing that struck me since the beginning, since today morning, was the complete there is no mention of the Wildlife Protection Act yet. And I wanted to kind of get the panel to reflect on the contradictory nature of the WLPA and the FRA. Whether as the FRA guarantees rights to forest dwellers, the Forest Department keeps using the Wildlife Protection Act to continue to criminalize activities that are deemed under the FRA. So, if Arpitha could reflect on that, and the panel could, be interesting.
Arpitha, you want to respond to that? And anyone else who might want to after that. But can we request all of you to keep your responses also to less than 2 minutes each?
Sure. Hi, Trishant. I think that's an interesting question. And I know sometimes the WLPA gets missed in this mix, but I know all the panelists are very aware of its extractive nature. But So I'll begin quickly with the comment that I made on conservation solidifying state control, and then quickly go into what I think are sort of internally conflicting laws. And I think that's a legal reality many are already aware of. So, in terms of conservation solidifying state control, I think there are two sort of legal aspects to it. One, in terms of the state's discretionary power, which is so amplified in forest laws that you don't necessarily see it in other legal regimes. Imagine to the extent where the forest department has the ability to categorize and draw boundaries on land, but at the same time can also criminalize forest dwelling communities for exercising rights. So it's literally a wide toolbox that they have for instruments of control. And that's sort of one reason I say that the state is fairly solidified and authoritarian in forest areas. The second reason it solidifies state control is because that primary conflict of who stewards these lands is contested across conservation laws. So there are different models of conservation that the panelists can speak better to it than I, but that the lack of resolution of that conflict in some ways creates a situation where the state emerges as sort of the primary steward, because community-based conservation laws have not, while they're recognized within the legal frameworks, have not been implemented on the ground as well. Whether you look at community conserved areas within the WLPA or even the idea of village forests, right, within the Indian Forest Act. So that's sort of where I say that the state is heavy and present with a lot of discretionary power and legal armor in these areas. And I think in terms of the conflict between the FRA and the WLPA, I think Shomona is better placed to speak to it, so I will yield to her. But just to make a quick comment that a lot of that conflict now is playing out right in the Supreme Court, again as sort of competing models of rights-based conservation and this idea of exclusionary conservation. And the nature of that conflict between the FRA and the WLPA plays out in so many ways, but I've kind of seen that particularly in categorization of protected areas, whether, FRA applies in critical tiger habitats or critical wildlife habitats.
Arpitha.
And yeah, I'll stop. But yeah,
It's such a horrible thing to do. I'm so sorry.
I think it's great. It's great. No, I just wanted to stop with that and also say that to be sort of mindful of the use of criminal law in how the FRA gets diluted. I'll stop.
I actually wanted to use the privilege of the chair to extend it by 2-3 minutes, because I know several other people who have a very strong thought process on this Wildlife Protection Act and how it interplays with other laws in India. Shomona, you want to go? Because I think all of us get agitated by it enough, and some of us really get pissed off with such contradictory laws continuing to exist on the statute.
Yeah, so I'm actually trying to shorten what I have to say, because a very dangerous person sitting next to me. Actually, if you look at the Wildlife Protection Act and its sort of legislative history, so in 1972, when it was enacted very much along that fortress conservation, very, very much a mirror image of the 1927 Act, and, sort of more because the criminal law provisions are much, much stronger in the Wildlife Protection Act. But one very interesting thing that I found in a study that I had done of the legislative history is that over the years there was obviously pressure on Parliament and on the government that there's something wrong with this approach to wildlife conservation. So there are amendments that have taken place in 2000, in 2002, and most particularly in 2006, the one relating to the tiger reserves. where tiger reserves were converted from an administrative category into a statutory category. And there is a very clear provision in section 38V which says that you have to settle forest rights, you have to consult the Gram Sabha, you have to have a case-by-case analysis of whether coexistence is possible. And if the Gram Sabha consents to the formation of the tiger reserve, they have to consent to the rehabilitation package. So it's a very it looks like an odd thing that has landed in the middle of the Wildlife Protection Act, but there's a history to it. Now the interesting thing, and I'm glad you've brought it up because I had actually written it down as one of the things that I wanted to talk about, is that the Forest Rights Act is not operating on an island. It operates inside a universe of laws which include the kind of laws that that Namita called the laws of the sovereign, as in the state which is the sovereign and the sovereign which is the people that are the sovereigns. So and it's very important, I think, as people to recognize that we have to understand how the FRA interacts with these legislations, and we have to remember that there are clashes. So how are those clashes going to be resolved? This is an everyday job for me and my team, certainly. But one of the things that I want to actually put on the table for everybody is that we are seeing a very, very alarming trend of expansion of conservation areas across the country. And starting with just before the Forest Rights Act was enacted, there were 41 tiger reserves which were declared across India. And they are, each and every single one of them has violated the Wildlife Protection Act. There is not a single tiger reserve that has been declared under the WLPA lawfully. The alarming thing that I find is, and to just disagree with Fernando here about, you know, the fact that lawyers are, that there's too much lawyering happening. Not enough lawyering. For the longest time, I've been trying to get somebody to file a challenge to those, at least one of those tiger reserves. Not happening. And instead, what is happening is that the forest department is creating elephant corridors, tiger corridors, eco-sensitive zone, buffer zones, and expanding. And you look at the maps and see how, you know, say for instance, we were recently in Nagpur, and the Vidarbha region, 1/3 of the Vidarbha region is going to become a protected area. So, and what do we do with the Forest Rights Act in that kind of situation? It is a challenge for us, and we have to find that solution. I'll stop here because there's this blank
which means you have no time
paper. Okay.
So sorry for this, and when I some point after this come to each of you asking for help and understanding, you will not say that you have only 2 minutes for me.
No. So on the Wildlife Protection Act, please, I'm plugging my own book on criminalization of Adivasis. We struggled to figure out what are the crimes under the Wildlife Protection Act, specific acts. The basic principle of criminal law that a crime should be clearly defined. That principle is violated because you can't understand what is the crime.
That book I'll also highly recommend to everyone who wants to look into this arena. To me, I think this panel has set out for LCW a little charter of things to be done over the next couple of years. Each one of those strands, I think, are 5 or 6 things we've noted that we'll work upon. I hope we have the resources and abilities to do it.